Yes, counsel. Good morning.
Good morning, Your Honor. May it please the Court, Richard Klebanner for the defendant, Appellee Nakia Lane. Your Honor, I believe there are two issues really at the core of this case at this point. The first one is whether the trial judge, Judge McCann, abused his discretion when he found that trial counsel's failure to call the witness, Mr. Levesque, was manifestly unreasonable. And the second issue is whether in doing, and the second issue is whether Judge McCann's decision on this point was entitled to deference before the appellate courts.
Well, don't you only, the abuse of discretion comes up as, doesn't it, in terms of whether it's entitled to deference? Otherwise, it's sort of like we could look at it, it's an error of law. It just seems to me once you say abuse of discretion is the standard, you are looking at some deference, aren't you?
Yes, I think that's,
Maybe it's just theoretical. Never mind. Go ahead.
I think that once you, I think the reason it's entitled to deference is, as Your Honor says, because the standard is abuse of discretion. That's at least part of the reason why it's entitled to deference.
What you're saying is that you disagree with the appeals court that it's sort of de novo.
Exactly, Your Honor.
Now, is it the case, and I know you say in your brief that it is the case, and I haven't had a chance to look at the record, that no witness was allowed to testify to Levesque's description of the shooter?
That's correct, Your Honor. The trial counsel tried on a couple of occasions to question police witnesses as to what Mr. Levesque had said. On each occasion, Commonwealth objected, and the objection was upheld.
And the same is true as to Levesque's failure to pick out the defendant from a photo spread.
Yes, Your Honor. And furthermore, of course, the judge, as is common, instructed the jury at the end of trial not to speculate as to what anyone who was not a witness would have said.
But you did get, remind me, did you get a Bowdoin instruction? Was there a Bowdoin instruction given?
I believe there was, Your Honor. And the appeals court seems to say that essentially the reason was not, they concluded was not manifestly unreasonable, is because there was a Bowdoin theory as part of the defense.
But it seems to me, well, let me ask you, is your point not that there's a Bowdoin theory, the police didn't do what they should have done, but it also calls directly into question whether they've got the right guy, regardless of what the police did. You've got this eyewitness who's unrelated to the case, so it has nothing to do with the police. It's just the fact of a direct description that is very contrary to what your client looked like.
Yes, Your Honor, and that's what the trial judge on the motion for new trial finds is critical.
So it just seems to me that's a very different theory.
It is a very different theory. The appeals court seemed to think that because it was a Bowdoin theory, it somehow made this other theory less important. I just don't think that's true on the facts or the law. In fact, trial counsel said that he went in with two theories. One, the Bowdoin theory. Secondly, the theory that I have this witness who will give you a different description. He then says, when I didn't call Mr. Levesque, I retreated to the Bowdoin theory, the trial counsel's words at the motion for new trial.
Was the ID by Stacy Kresnecki a cross-racial ID?
I believe it was, Your Honor. I couldn't tell you that that's in the record. And I wasn't trial. Personally, I've never seen Ms. Kresnecki, so I can't make that representation. There were other problems with the ID in any case, I suggest, Your Honor.
So I gather nobody argued that that it's less reliable because it was cross-racial.
No, Your Honor. I don't believe that was argued. It was certainly argued that certainly evidence was introduced as to other problems with the ID. She made a partial ID. She picked out two pictures. The police, as she looked at Mr. Lane's picture, the police said to her, "Oh, you're having a reaction," basically. It was not seriatim, as is now recommended. It was not double-blind. There are a number of problems with the ID, as well as it simply not being a very firm identification.
Let me ask you this. Are we limited to the analysis of the judge with regard to counsel being ineffective? I mean, this is not an appellate finding here. This is the finding by the trial judge himself. What if the trial judge simply had said, I'm uncomfortable with this finding because without hearing, I mean, having heard now from Mr. Levesque in the motion for new trial, I don't feel sufficiently comfortable here that this person should be found guilty. Is that something that we may consider, or are we limited to what the judge said was the basis for his finding?
Certainly the judge could have said that. And as this court, I emphasized, I think in Pring-Wilson, on that particular type of question, the judge has a very broad discretion and quite a bit of deference. He did not say that, Your Honor, and I think I would have to concede that before this court, the question is whether he abused his discretion on the question he did decide, which was ineffective assistance.
Now, would it have been appropriate for Judge McCann to have ordered defense counsel to call this witness? Saying that if you don't, it's going to be ineffective and it's going to require a new trial, therefore I direct you to do this.
I don't have an answer to that question, Your Honor. Frankly, I don't know if a trial judge has the power to require, to dictate the terms of defense. I simply don't know the answer to that, Your Honor.
It would be rather extraordinary.
It would be certainly very unusual, Your Honor.
And does that, though, affect our analysis as to whether counsel was ineffective? Or do we simply say that there are things that a trial judge just can't control? A trial judge sometimes just has to try a case knowing that it's going to be reversed because counsel's ineffective and there's nothing a trial judge can do about it.
Well, I would say that during trial, Judge McCann didn't have all the facts in front of him as to what, as far as I know, as to what Mr. Levesque would have said. It was at the motion for new trial that the detailed information as to what would have been testified to came in.
Well, plus he also had a chance to see him, Levesque.
Yes, Your Honor. At the motion for new trial, he had a chance to see him.
And he could compare. I mean, he could assess the credibility of the witness and the likely impact he might have had on the outcome of the trial.
Exactly, Your Honor. And he specifically finds that this is a disinterested and credible witness. He says Mr. Levesque had some slowness in answering questions, but he was able to answer all the questions.
And he also said that with respect to that problem, he seems to describe it as sort of like a mechanical problem.
Yes, Your Honor. He calls it a processing problem. I don't know exactly what he's referring to.
He didn't think that he was prevaricating or, trying to sort of shade the truth. It wasn't that.
Not at all, Your Honor. He specifically says he was a credible witness.
Well, one of the things that a trial judge can do, presumably, is to inquire of counsel as to why counsel has chosen not to do something that appears to be obvious, just to protect the record, to ensure that it was the product of some strategic reasoning. But that sort of happened here. I mean, counsel did explain why he was not calling the witness.
This comes up in connection with the request for a missing witness instruction by defense counsel. And at that point, Judge McCann says, well, you could have called him. You can't have a missing witness instruction for somebody you could have called, you had available. And trial counsel says, well, Your Honor, the burden is on the Commonwealth, and I did not want to marry myself to Mr. Levesque.
So that was the first time this little conversation occurred? There hadn't been any earlier discussion about whether he would be calling Mr. Levesque or not? Because I haven't read the record.
No, Your Honor.
I know it did come up, but it came up in context of a jury instruction request.
Yes, Your Honor.
Before the end of trial?
Yes. Yeah, before the jury, before closing arguments, I believe. I don't.
But after the close of evidence?
My memory is it was after the close, after the defendant had rested, Your Honor.
So you can see why this is certainly troubling to the appeals court because there really was a rationale for not doing this.
Well,
I mean, it wasn't mistake, complete. It wasn't I forgot or gosh, I forgot to subpoena him or, I really didn't pay much attention to that. I should have interviewed. I mean, it was very conscious, deliberate, based on a plan to pursue this Bowden thing because that, in his view, would be the most successful approach in light of how the case
I think
evolved.
that's going a little further than the record, Your Honor.
Okay.
Yes, it wasn't a mistake. I mean, it wasn't a mistake in the sense he forgot. I mean, that's true. He had Mr. Levesque sitting out in the hallway.
And he had talked to him several times, so he had a good
He
sense
seems to
of
have
him as
talked.
a
Yeah, he seemed to talk to
potential
him several
witness.
times. Exactly. So it's a tactical decision. The question is whether it's a manifestly unreasonable tactical
You're
decision.
saying the idea that the value of not marrying yourself to a witness, taking precedence over not calling a witness who really has very important exculpatory evidence to offer, is manifestly unreasonable.
Yes, Your Honor. That's exactly the argument. And it's
can I just, Commonwealth seems to be arguing that the jury knew everything through other witnesses.
Right.
And you seem to be taking the opposite point of view, that the jury did not know everything through the other witnesses.
what the jury heard was a question such as, did you ever look for a man? Defense counsel asked police witnesses, for instance, did you ever look for a man matching a certain description, which turns out to be the description Mr. Levesque gave.
He didn't identify it. He just said a light-skinned male, et cetera.
Yes.
Is that right?
Exactly.
Okay.
Right,
No,
right. He
I
could not,
didn't mean to
he did not,
interrupt.
yes, Your Honor. And that question was objected to. So that never came into, and the objection was upheld, so that did not come into evidence. And of course, the judge instructed the jury at the end that questions aren't evidence.
So the jury never learned what description Levesque gave
That's correct, Your
to
Honor.
police?
They never learned it.
Yeah.
They heard questions, but they never heard an answer.
There's another thing I think that is important to the calculus here that you haven't mentioned, but you talked about in your brief, and that is that the defense lawyer, in his opening statement, gave what was, if it was an express promise, if it was not an express promise, it came pretty damn close to being an express promise that the jury would hear from Levesque, and they never did, and that really kind of undermines whatever defense was left, and the judge took that into consideration as well.
He certainly did, and that was one of the motion judge says that this is a very important point, that it was promised. And motion judge had no question in his mind that this was a promise to produce testimony. Defense counsel, when I questioned him at the motion for new trial, said, yes, I meant I was going to call him when I told the jury that. And as Judge McCann points out, it undermines your credibility with the jury to tell them you've got a witness who's going to say very specific things and then not put him on, leading the jury to conclude that there is no such that there probably was no such witness who would have said.
So if the opening had not been made, this might have been a different case. That may have the sort of the shifting of gears mid-trial, combined with the failure to call this witness, may have made it a different case than if.
Certainly the combination makes it a much stronger case, Your Honor. I would certainly argue, even without the promise, that it would be that Judge McCann would have been well within his discretion to make this finding.
But the judge made the finding.
Yes, he did.
You don't need to go there.
I don't need to go there, Your Honor. That's quite correct. So I think at the end of the day, Your Honor, what Judge McCann said was counsel was constitutionally ineffective in referring to a potentially exculpatory witness in his opening statement and then failing to call the witness to the stand. I can only say that this is an honest conclusion of a conscientious judge and is entitled to the proper deference and should be upheld by this court. If no further questions, thank you, Your Honor.
Good morning. May it please the Court, Jane Sullivan for the Commonwealth. The Commonwealth would ask the Court to reverse the order of the trial judge allowing the motion for new trial and affirm essentially the appellate court, the appeals court's ruling in this matter. The appeals court ruled that trial counsel's tactical decision, and it was conceded from the get-go that this was in fact a tactical decision, and the record is entirely clear from the trial transcript and the transcript on the motion for new trial. It certainly was tactical, and this constituted the quintessential strategic judgment that should not be second-guessed. The task before the trial judge on the motion for new trial was to determine whether or not the strategic decision not to call Mr. Levesque, who was present at the trial, with whom defense counsel spoke repeatedly during the trial, whether that was manifestly unreasonable. The question is...
It strikes me as like the question I just asked, that the fact that he raised this in his opening, told the jury they should expect to hear, and the judge concluded that was actually a promise to produce, doesn't that make a difference here?
If it makes a difference, it's a difference to show that it was a strategic judgment that was not manifestly unreasonable.
Sometimes we say that changing strategy in the middle of trial and dropping a defense, which is apparent on its face, may be manifestly unreasonable.
That may very well be, but that is not the situation here. First of all, there was no promise, as in McMahon or Duran that are mentioned in the briefs, that the defense was going to call Levesque as a witness. The appeals court...
That's the fair... I mean, when you read the opening, don't you think that's a fair interpretation of what he was saying?
Not at all, Your Honor. If you look at it in context, he's talking about what the Commonwealth is saying that they're going to present, and they're going to present Stacy Krasnetsky, and they say, you didn't hear anything from the Commonwealth, the prosecutor, about Levesque. But Levesque is at the scene. Levesque gives a description. He's brought to the station with Krasnetsky, and he gives a description of a shooter different than Stacy, and it's the description 5'3", slim build, light skinned, Hispanic, mulatto. And that's all before then. He said, and I expect that you, all he says is he expects that you would be able to hear that.
So how did it come before the jury? How did all that evidence come before?
The evidence it doesn't come directly. It's about roundabout. But if you look on transcript, volume 3, page 45, it's defense counsel's cross-examination of Detective Sawyer. And without objection, and they've already established through cross-examination that Levesque was a witness. He gave a description of the shooter. He was brought back to the police station. And he's asked several questions, and they were objected. But this question, you never entered the biographical information into the computer system searching for photographs of a Hispanic male, 5'3", slight build, early 20s, short black hair, right? No, I did not. And you never showed a photo array of any individuals that met that description, right? No, I did not.
Well, how do you reconcile that with the judge's instruction at the end of the trial that you're not to speculate about what any witness might have said who didn't testify before you?
But the jury they were instructed that you can draw inferences from whatever testimony there was, and by the time the defense counsel presented 3 more witnesses, police witnesses. They put on an affirmative case. It was 3 more witnesses that laid out about Levesque being at the scene. He's up and mean. He's shown a photo array, and nothing else happens.
But the question is, did it ever get hooked up together for the jury that this was the description that Norman Levesque had given the police of the shooter?
I would suggest, yes, that was the obvious import of the testimony of everything. And if you consider the defense counsel's opening statement and his closing argument, when he sums it up all together, he says Norman Levesque was there. He gives a description. Then they don't hear any more from Norman Levesque. Norman Levesque is not allowed to have his information entered into a computer system and generate a photo array like Stacy Krasnetsky's was.
Can't take the opening statement.
No, that's closing argument. That's the closing argument. That was the closing argument.
They can't take that either.
No, it's not as evidence, but it's the inferences that the judge, the trial counsel is urging the jury to draw from the evidence that was actually admitted.
But you objected to the questions that would have directly elicited what Levesque said.
Yes, they did. Yes, we did.
So I mean, how can you have it both ways?
Well, because one question came in without objection, and the reason that the prosecutor did not object was because Levesque was there. It was our position that there was no basis for a missing witness instruction. If the defendant wanted to call Levesque, he should call Levesque. Defendant did not want to call Levesque, and defense counsel made clear in the motion for new trial and his testimony, he did so. He came to that decision after speaking with Levesque when he was talking up to him about his descriptions of persons that revealed inconsistencies that were troubling to defense counsel, and defense counsel considered Levesque then a damaged witness that would do more harm to his defense than good.
Did the jury hear any evidence that that Levesque had looked at a series of photographs, including the defendant's photograph?
Yes.
And did not pick him out?
They didn't get to the ultimate question, did he pick one out? It got up to the point was he was given the photographs, the array included a picture of the defendant, and then they don't hear any more from Levesque. It's as though the Commonwealth, as he argued in closing, wants him out of the case.
So, do I understand correctly that it was at trial where the defense counsel was saying, I don't want to marry the witness, right?
That's at trial. It's
Okay.
clear from the beginning that he's out there. Now, if Judge McCann wanted...
No. Oh, hold on. Okay, that's trial. But at the motion for new trial, he abandons that theory of why he wasn't calling him, and he says it's because I was concerned about him. I thought that I was going to be hit with these inconsistencies, and I didn't think he was a damaged witness, as you just put it. He says that
his conversation with him during the trial revealed inconsistencies, and the conversation was substantive, and it concerned his descriptions of persons.
That's what
he says at trial, and he does not.
Not at trial. At motion.
At the motion for new trial, he reiterates the exact same thing. He makes clear that he did not. It was his memory that he didn't want to have to align the defense with everything that Levesque would say.
Is this the case where, does he say, I don't remember why?
That's in his affidavit. In his affidavit that was submitted initially, he says, I don't remember. But then, and it's on cross-examination by the prosecutor when the prosecutor's asking him about statements that were made at trial, and it does refresh his recollection. I think he says, now that you're going through this with me, I remember. I have a distinct remember. It was that conversation out in the hallway about the inconsistencies that came up in the description of persons when I decided, I knew it was a huge moment at this trial, but when I decided that he was not going to be a good defense witness, and I could, it wouldn't be ideal, but I could get what I wanted in another way.
So the judge who sat through the whole trial,
Yes.
who heard defense counsel testify at the motion for a new trial, and who heard Levesque testify at the motion for a new trial, nevertheless concluded that there was ineffective assistance of counsel and ordered a new trial. How did the judge abuse his discretion?
He abused his discretion in a couple of ways. First, he didn't make any real findings of fact about what trial counsel said or what Levesque said. All he says was that that counsel's decision deprived the defense of having Levesque's description of the shooter or his failure to select defendant's photograph admitted for jury consideration. Well, that is, and I would suggest transcript 3, page 45, proves that to be clearly erroneous. The description was presented to the jury.
That's if you knit it all. I mean, that's really not totally fair, is it? I mean, that's if the jury is knitting together a series of,
That's what we ask juries to do all the time. That's what they do. That's what inferences are. And this is not
So the judge knew that, and the judge also saw Levesque, and he said, this guy's a credible witness.
He said he's a credible and disinterested witness with processing problems.
Yeah.
That there was some sort of obvious problem in the way he related. And Levesque, I would contest, too, the fact that he had this, unchallengeable exculpatory evidence. On cross-examination, I suggest he proved that trial counsel had legitimate concerns about him. He did not stand up well on cross-examination. He admitted he could not tell what the male had, the light-skinned male he described as a shooter had held in his hand. He said he thought it was a gun because he heard the shots. It could have been a cell phone. There was differences of how many people were around the shooter. He places Stacy, she testified, she was right beside the victim at the time of the shooting. She's 20 to 30 feet away. He admits that there's a pump in his line of view.
Are you saying that the judge's credibility assessments were incorrect? As a
I'm
matter,
saying
as
the
a matter
judge's-
of law, they were
I'm saying the
plainly
judge's
wrong.
legal assessments of manifestly unreasonable and on the facts of this case, both at trial and in the motion for new trial, are, yes, as a matter of law, the judge erred. And in this case, I mean, I don't know where you would have a reasonable strategic judgment. This is just the judge second-guessing the lawyer, and that's what Strickland specifically prevents a judge from doing. And the judge, in ruling on this motion, should have, he was required to give some deference to trial counsel's decision. He gave none. Instead, I would suggest that he substituted his judgment years down the road for that of trial counsel at the time. The judge made no mention when trial counsel was saying he didn't want to call him, he doesn't want to marry him, he doesn't think he doesn't have the burden of proof and he shouldn't have to be aligned with this guy. The judge did not insist at that time that trial counsel call the witness. And he
Ever heard of a judge insist of a defense counsel to call a witness?
No, and I would suggest that that's absolutely wrong. But in essence, that's what we have here now, years after the fact, after the conviction. And I would suggest that the appeals court got it right, and they accurately reviewed the record as it was, applied the appropriate legal standard, whether it was manifestly unreasonable counsel's actions. It's clear that it was not. It's not a case like Hill or any of the other cases where a counsel may make a snap judgment without knowing or thinking about the alternatives and what the plausible options are. The defense counsel knew what the options were. He weighed them. This was his decision to make, and I would ask the court to affirm.
So what is the discretion that we give a trial judge in ordering a motion for new trial?
Well, I think it's a little different on a strategic judgment that has to be shown to be manifestly unreasonable. But a judge does have some discretion, but a judge can act frivolously or contrary to law. And I would suggest...
And which one did he do?
Contrary to law. He did not apply the standard of manifest unreasonableness correctly
And
to the facts in this case.
Why can he... I mean, isn't there a matter of discretion involved in deciding whether it's manifestly unreasonable? Because he based that in part upon the witness's testimony and the attorney's testimony. Isn't there some discretion that we give for the judge who actually heard that testimony and could evaluate whether it was manifestly foolish for him to have promised this witness and not called him?
Well, first of all, I take issue with the fact that I do not believe that there was any sort of promise. This is not shifting a case where he shifted, midstream. He changed defenses.
Do we give no deference to the judge who was there and heard the openings and took it as he did? I mean, everybody can read the paper now, and
But I think-
it can admit of different readings.
But
the judge
ultimate-
was there and heard it. Don't we defer to the judge's assessment of what that means?
His assessment was that it was a promise along the lines of McCann and Duran. And if you look at the cases of McCann and Duran, it's not. It does not rise to the level. So the Commonwealth's argument is that the judge erred in applying the law. Whatever discretion he may have factually, he applied the facts that were before him. And as I said, he made no specific findings of facts other than that Levesque was credible and a disinterested witness. So his ruling is essentially a legal one, and I would suggest it's an incorrect legal one. And because that's a very high standard, and the cases say that it's very rarely will you find a situation where a defense counsel's reasoned strategic, where he's looked at the options and makes a decision, will be a basis for a new trial.
I don't know, I'm just speaking for myself. There's very little question that the judge had denied this, that would be very hard to overcome for exactly what you say.
Right.
Because this was clearly a strategic decision, and it had been thought about. But we're on the other side of that, and could a reasonable judge conclude otherwise?
Well, the judge doesn't say that in his findings. His ruling is limited to ineffective assistance based on manifestly unreasonable strategic decision. And he gives two reasons for that. One, that the description never got before the jury, and two, that it completely abandoned the misidentification defense. And neither of those are true. The defense counsel extensively cross-examined Stacy about her identification. He argued from the beginning and in the closing that it was a misidentification, that whoever shot at the victim was not the defendant. And I would just suggest, too, this was not strictly an identification case. There was compelling circumstantial evidence of a gun, or that the defendant, an hour after this shooting, used the same gun, a .22 caliber gun, to shoot up his girlfriend's landlord's apartment. 7 bullets in there. There was ballistics evidence connecting the two scenes. So I would suggest that, on the whole, Levesque did not have much exculpatory information to offer. But whatever it was defense counsel's decision at that time to make.
But the jury was hung in this case until, I mean, the jury was deadlocked until they got a Tui Rodriguez charge.
Well, they did get a Tui Rodriguez charge, but the testimony went over a number of days, and the jury really wasn't out that long. They were out for, I think, maybe 3 or 4 hours the first day. They had a full day, and then they were back in an hour.
But I assume they told the judge we're deadlocked.
They did. They did come back and say, we can't come to, yes, and they did say that. So I would ask the court to affirm the defendant's conviction. Thank you.